fixed place of abode away from the scene of crime. He submitted that the state must show that there is real intention of absconding trial. Mr. Kimilu, learned counsel, also urged the court to consider that the applicants have failed in their obligations to demonstrate compelling reasons. The Court of Appeal Authority, the case of Michael Juma Oyamo and another versus Republic in Criminal Appeal number 113, where the court went to great length to define what amounts to compelling reasons, where the court adopted the definition as follows. The phrase compelling reasons would denote reasons that are forceful and convincing as to make the court interference. The case of Republic versus Dwight Sagare, criminal case number 61, and the Public versus Richard David Alden, the court dealt with the issue of witness interference. We finally submitted that there has been no attempt by the accused to abscond, and therefore is not a flight risk. So juxtaposing the applicable text set out herein in this ruling as to whether the applicant has proved compelling reasons, four broad reasons have been advanced by the prosecution as compelling reasons, namely flight risk, safety of the respondent and public order, seriousness of the offence, and lastly interference with witnesses. I'll start with seriousness of the offence. It cannot be underscored to the fact that the charge hearing that the accused is facing is grave and weighty. The seriousness of the offence in terms of the sentence likely to follow a conviction has been held repeatedly to be a consideration in exercising discretion. The seriousness of the offence has a clear bearing which the court ought to bear in mind on the factors influencing the mind of an accused facing a charge in respect of the offence as to whether will be a good thing to skip or not, and such possibility is not out of question. It has happened before and in similar cases. There is a case of Watoro versus Republic, Kenya Law Reports. I will not wish to belabor into the propriety of this limb, basically because standing on its own cannot be a ground to denying bail, but ought to be fortified and underpinned by other factors. Those are issues also which were addressed in the case of Republic versus Zakaria Okoth-Obado, 2018. Similarly, in the case of Republic versus Salim Said Nasoro and two others, High Court Criminal Miscellaneous Application number 315 of 2026, where the court again held that the seriousness of the offence per se is not a basis for denying bail. Additionally, in the case of Republic versus Sabit, Mamour Den and another, the Superior Court held as follows, and I will quote, however, in the current constitutional order, murder is an offence like any other for purposes of bail pending trial, and therefore a bail application in a murder case, as in any other case, has to be looked at from the prism of Article 49(1) H of the Constitution, and the key question that takes center stage is whether the accused person will turn up for his trial if released on bond. Consequently, in the premise, the fact that only the respondent will be likely or face serious charge is no reason to deny him bail. Courts have also adopted innovative mechanisms and processes that ensure the accused person granted bond do not abscond. On the issue of flight risk, intertwined to the above is on the likelihood of the respondent absconding. The paramount issue is whether the respondent will attend trial or whether there is likelihood of absconding. It is the rule of thumb and compass that should guide the courts. This is in dispute that the accused presented himself at Muthaiga police station And also it has not been controverted that the accused does not have a fixed place of abode and without familial ties. The evidence submitted was that the accused, through a signal to the police headquarters, was declared a deserter and he surfaced after 15 days. This is a valid ground, and an inference may be drawn that he may abscond. Safety of the respondent and public order. On this issue, the deponent informed the court that the incident elicited widespread anger and outrage, leading to demonstrations in Garissa and along Garissa Mwingi Road. And therefore, the safety or security of the respondent cannot be guaranteed. In the case of Republic versus Mercy Chebet, Justice Kikonyo has strongly vocalized himself in no uncertain terms that at this time and age, such ground cannot meet the threshold of compelling reason. The judge goes further to correctly state that it is the duty of the state to provide safety and security to its citizens. This position was also held in the case of Republic versus Mjurwa, where the court held. This court's view is that the ground that the security of the accused is threatened by members of the public or family of the deceased should never be encouraged as a ground for denial of bail, unless there is real evidence of actual threat, lest we should inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. Therefore, I find the arguments that the accused, be denied bond for his own safety and security without real evidence, without real evidence, and without legal and factual basis. Interference with witnesses and investigations, witnesses especially. The prosecution alleges likelihood of interference with prosecution witnesses in a host of authorities, that this is the most potent ground. If proved, is the prosecution's allegation of likelihood of interference with prosecution witnesses as such amounts to an affront to the administration of justice, thus justifiable reason to limit the right to liberty. In the case of Jackton Mayende and 3 others, the court held, and I will quote, "In all civilized systems of court, interference with witnesses is a highly potent ground on which the accused may be refused bail. It is a reasonable and justifiable limitation of right to liberty in law in an open and democratic society as a way of safeguarding administration of justice. Undoubtedly, a cardinal tenet in criminal justice, social justice, and the rule of law in general, as envisioned in the preamble of the Constitution. Threats or improper approaches to witnesses, although not visibly manifest, as long as they are aimed at influencing or compromising or terrifying a witness, either not to give evidence or to give skewed evidence, amount to interference with witnesses, an impediment to or perversion of the course of justice, if the interference is aimed at impeding or perverting the course of justice, and if it is so found, it is a justifiable reason to limit the right to liberty of the accused." As it was held in the case of Republic versus Dwight Sagare and 4 others, 2013, for the prosecution to succeed in persuading the court on this criteria, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of a threat or threat to witnesses, direct or indirect, incriminating communication, between the accused and witnesses, close familiar relationship between the accused and witnesses, among others. It is therefore incumbent that the prosecution needed to demonstrate with tangible evidence of actual interference or a likelihood of interference. Therefore, the court must strike a perfect balance that ensures that the trial is not impeded by acts of interference with witnesses, but at the same time upholding the rights of the accused within the general spectrum of the Constitution. It can also not. It is also not in doubt that the incident occurred in Garissa, that is a scene of crime. It is also not in doubt that the accused is a police constable in the National Police Service with the rank of is a police constable. It is also not in dispute that the majority of witnesses will be from Garissa County. It's also not in doubt that the accused, having served for a period of 7 years at Garissa, wield significant influence and or has familiarity with the said area, and there is a likelihood of contacting the witnesses. Cumulatively, the well laid down evidence point to the possibility of the accused interfering with the witnesses. I can state that the prosecution has credibly and specifically demonstrated the likelihood of such interference. The fears of the applicant that the presence of the accused is likely to have on the witnesses is not far-fetched, and it's contrived based on, and I'll quote, the Blue Code of Silence, which the Court of Appeal, in the case of Titus Ngamau Musila Katitu versus Republic 2020, ascribed that it's a common phenomenon spanning across different countries in America, Europe, Asia, and even Africa. The said court went further to demonstrate incidences where police in Kenya have engaged in the practice of covering up for each other. Having served the police service specifically in Garissa County for approximately 7 years, it is clear he has created a robust network with fellow police officers who are likely or may cover up for their own. This issue was also raised in the case of Republic versus Police Constable Samson Murioki Mbui 2006, the case of Veronica Gitai and another 2017. These are some of the examples where the superior courts have expressed concern over police cover-up of crime involving police officers.